Welcome to Conflict to Clarity in Family Matters with Rahul Kishore.
Welcome back, everyone, to Conflict to Clarity with Family Matters with Rahul Kishore. Rahul is a trusted Maryland divorce lawyer with over 30 years of experience and a strong background in finance and business law. I'm Evan Mack. In today's episode, we're breaking down two very different paths for resolving a divorce. That's mediation and litigation. This is Mediation versus Litigation, What to Expect in Maryland Divorce. Welcome back, Rahul.
Thank you for talking to me again today.
Let's get right into it, though. Let's kind of start with the basics for the people that don't really understand. Let's try to give them a kind of bird's eye view. What is divorce and mediation, and how does it work in Maryland?
Well, divorce is going through a controversial process where you're splitting up with your spouse. But what mediation is, and which is something I encourage, and I am a mediator here in Maryland. I've been trained in mediation. I'm actually sometimes appointed in cases through the court system, but most of my mediation practice is a private mediation practice. And what mediation is a way for you and your spouse to control the situation, come up with solutions with the help of a third-party mediator who is not representing either party, who helps you go through the process and helps you come up with different solutions and directs you in a proper way to come up with the marital settlement agreement. I can act as a mediator as long as I haven't represented either spouse prior to the mediation. So people have to approach my law firm and say that me and my wife are looking for a mediator, me and my wife or me and my husband are looking for a mediator, and we want to hire you, and people can come in, both spouses. I don't represent them as an attorney, and like I said, I'm a third-party neutral, and I can never represent either of the parties later if they end up not settling the case, or I can't help them in any part of the litigation or filing of the case after. Even if we come up with a mediated settlement agreement, I'm only allowed to help them through that process, and then they're going to have to file a complaint afterwards on their own. But just to explain it to you, that mediation is a process that you control, you and your spouse control. You have a lot of privacy. It saves you a lot of money and time and efficiency if the process is successful. And through my 30 years of practice, I can tell you that a majority of our cases that go to mediation do settle. And the bottom line here is I want to explain is that if I act as a mediator for two people, I am not their counsel, but there is a lot of mediation that I do in my private practice where I'm representing either the husband or the wife or one of the spouses in a case, and we go to mediation where both parties have counsel there, and we hire a private mediator. So there's usually about 5 people involved in the mediation, and we do that as well.
So, Mr. Kishore, what does litigation look like in Maryland divorce? And when does that become necessary?
Okay, I'd like to emphasize that mediation is only one way. I have a practice that we are very aggressive attorneys if that's what our client is looking for. And if me and my client sit down, we have an initial meeting, we figure out what are the goals of my client, what is the relationship between the spouses, what is the history of the relationship, what is the information that each of the parties know about the other party. We come up with the solution, sir, to figure out whether mediation is something we can do. And a lot of the time, that doesn't work. And the times that it doesn't work is when there is not a level playing field between the parties. So a lot of the time, for instance, if there's been a history of domestic violence, or their parties are not transparent about their finances, and they don't know anything about the other parties, how much they make, if they have an investment account, whether they have a business that they own, and one party is running a small business, which I represent a lot of people who own small businesses. Like I do have a very strong business background. I have an economics degree and I have a finance degree undergrad, and I have an MBA. So I do a lot of cases where there's owners of businesses. And so what happens in that situation, sir, if the other spouse does not have the information regarding that business, how much money is being brought in, how much do they pay their employees, are they swindling money outside and calling them business expenses, how much are you getting in cash through the business that's not being shown? There's so many issues. And if one of those spouses, or if the spouse I'm representing doesn't have knowledge of that, the bottom line here is I'm not going to recommend doing mediation unless we have a lot of the information that's transparent. And we're never going to try to mediate a case where there's been, let's say, even physical or mental abuse of a child. Okay, we're not going to mediate with somebody about how to give custody. So there is a lot of situations where we do not recommend mediation, and we go to litigation.
Okay, so what are the biggest advantage though of choosing litigation over mediation, or vice versa?
Okay, well, the advantage of litigation for the disadvantage of litigation is it's going to take a lot longer and it's going to cost more money. But as I said, in mediation, we always try to do that. But I've given you the main reasons why we don't do that, and there's a lot of situations we don't recommend that. The bottom line is that when you go to litigation, you have a lot of tools available through the court system to get the information and documentation that you need to help us represent you in a case. For instance, when you file a case, you do discovery, which is you could ask the other side to, under oath, answer questions. We can request them to produce documents. We can take a deposition of the other party. We can also subpoena documents when there's a pending case to get documentation. And that will provide the road or the path that we need to help you or my client through the process to get the information you need and to be able to represent you for all the claims that you have. And a lot of those claims are, for instance, what is marital property? Are you getting the value you need for the small business? Are you finding out about the investment accounts that your spouse has that he hasn't been disclosing? What is the value of the retirement accounts? Does he have any pensions, or does he have any stock options through the employer that he's been, vice president with? So I do represent a lot of executives who work at companies, and we represent the executive or the spouse that is trying to get her share of whatever she or he is able to get from the other spouse. So we need to use all the avenues that are available. But like I like to stress, that doesn't mean that we can't settle the case later. We can always go through mediation, which the court process allows us to do, and they require us to do in Maryland in all cases, except if there's a reason that the court's not going to send us to mediation, but they normally do. So my job is to get the information, file a case, and aggressively represent my client. But later on, we will always, like I said, my law firm is all about trying to save my client money and time. And if at certain stages of the legal process, if we have the information and gotten it because we went down this road, we will go and mediate at that time and see if we can come up with a settlement. And that is something I always try to tell my client that we will do. Of course, there's many situations where our clients do not want to do that. I go to court every day, and I have been for the last 30 years, and we will go to court if that's the main strategy or the main option that we have to get the solution that we need for our client.
So does mediation work well for all types of cases, or are there certain situations where you wouldn't recommend it?
Well, like I already said to you, I wouldn't recommend it if there's domestic violence, if
Yeah.
there's a control issue, and like I already said to you, I would never recommend it if there is no transparency or full disclosure of financial information.
How much can someone realistically save by choosing mediation over a full blown court battle? You talked about litigation being more expensive, but can we talk a little bit of numbers if you have them off the top of your head?
Well, let's put it this way. I tell my clients when they come in that we can do a mediation without filing a court case. You could do that. Of course, it depends on the hourly rate, but you could do a who if mediation, depending on how many mediation sessions you have, you could do mediation within four to five, six, $7,000. Okay, depending on the complexity of the case. So it's very hard to say. But if you go to court and go through the process, depending on, like I said a few minutes ago, I always encourage mediation during the divorce process after getting all the discovery and doing any depositions or any subpoenas. If we do it as early on, you could save, $10,000, $15,000, because you could, spend, let's say, $15,000. But if you go through a whole court process and you end up going to a trial, you could spend $30,000 to $50,000, depending on that. And these numbers that I'm giving you, honestly, are just estimations. It's just a kind of like not a timeline, but something that you can kind of get a barrage of what I'm trying to say. But it is in no way something that you can stick to that, oh, well, you said 4,000 to 5,000 on mediation and you're saying 10,000 to 12,000 if we settle before we go to trial, and 20,000 to 30,000. It could be twice as much depending on the complexities, how many bank accounts we're subpoenaing. If they're and that fee can also dramatically increase if you have a litigated custody case. Okay. And one point I'd like to emphasize is that in Montgomery County, this is the only county in Maryland where they bifurcate the case. And what I mean by that is the custody, you have a separate custody trial, and then you have your separate divorce case, which involves all the finances. But in other counties in Maryland, they only have one trial where they do the custody and all the finances in one case. So in Montgomery County, because you have a bifurcated two trials, the cost can also increase dramatically because of that.
So, Mr. Kishore, you've been doing this. You're coming up on 30 years. Why do you do what you do? Why do you still enjoy what you do? What keeps you up, and brings you to work every day?
Well, I'll tell you this. It's trying to help people and get them down to sit down, not have conflict, try to help them do something in the quickest, most process that's not painful. Okay, this is, emotionally, divorce is painful. Anybody can tell you that. It's the most painful thing to go through in life. And my job is to reduce the conflict, reduce the fees, assist my client, give them solutions and avenues that help them do this in the most advantageous way for themselves. And the other biggest thing that keeps me driving is, like I said, I got into this business of family law 30 years ago because I love children. And I think the least conflict you can have in a divorce case will be most advantageous for these kids. And they will have a stronger life, a more emotionally stronger relationship with both parents throughout their life if there's less conflict, and it helps them developmentally throughout their life if they don't go through a process where it is painful for them as well. And if they see that their parents can at least, have less conflict between themselves after the divorce and realize that both parents love them, that child will prosper a lot more after the divorce than when you have a situation where you litigate and you fight and each party ends up hating each other. That's what I try to do. Of course, that does happen in many of my clients' situations over the last 30 years, I can tell you. But I can tell you that I have successfully been able to do many, many cases in the avenue that I just described initially.
Mr. Kishore, and finally, if someone hits a wall during mediation, are they still able to switch to litigation, or are they kind of locked into that mediation process?
Oh, not at all. I mean,
Okay.
mediation is a voluntary process. It is not something that you have to go to. It's not like binding arbitration, sir. And
Mhm.
binding arbitration is a separate type of case, which in divorce cases we don't do normally. And binding arbitration is you go and you sit down and like there's an arbitrator or a mediator who says, okay, this is the final decision after I hear from both of you. That's not what we're doing. We're going to mediation. It's a voluntary process. It's a process that you and your spouse are able to come up with solutions that the judge would never be able to do. So what's one of the big advantages of mediation is that you can come up with many, many solutions that a judge will never ever come up with. Like, for instance, about custody. There are so many different avenues of visitation schedules, of coming up with holidays that you may have because you're from a special ethnicity, or if, for instance, you go to court and let's say that your family, your spouse's family celebrates Christmas on Christmas Eve and one family does it on Christmas Day. Well, if the judge doesn't know that and you both agree that one spouse does Christmas Eve with their family and the other does it with Christmas Day, well, you can come up with solutions that work for you and your family. I'm just giving a simple example, but that's what mediation allows for. But if when you go to mediation with the efforts of both lawyers there and the mediator, with the five of us, and sometimes, like I said, sometimes mediation's only with me and the two parties that have hired me, and it's just the three of us. If you aren't able to help these parties and they both are not voluntarily agreeing to something, which they should, before you sign any type of agreement for a mediated agreement, if you don't, then you just get up and you file for a complaint in court. One party will file. And I have to also emphasize one other thing before we finish today. The other benefit of mediation is that both parties, from my client, what we benefit is that if we don't come to a solution and a settlement, we do learn a lot of information through the mediation process.
Mhm.
And it's gainful information that I have been able to use for representing my client in filing a complaint or representing them in a complaint that's been filed against them after the
Wow.
mediation. So there's a lot of information you gain.
Awesome, awesome stuff, Mr. Kishore. Thank you so much again for your time.
No problem. Thank you for talking with me today.
Absolutely. And thank you guys all for tuning in today's show. Mediation and litigation each have their place, but the right choice depends on your goals, your spouse's cooperation, and the complexity of your situation. To find out which approach is right for you, visit marylandlawoffice.com and schedule a consultation with Rahul Kishore. And don't forget to like, subscribe, and leave a review if you found this information helpful. Thank you for joining us.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.